Good day everyone. In this video, we will be discussing the Public Act 4054, also known as the Rideshare Tenancy Act, one of the earliest laws in the Philippines that aimed to address the long-standing agrarian problem between landlord and tenants. But before we formally begin with our discussion, let me share a brief history on how this law was enacted. So in the early 1900s, from 1903 to 1938, there was a steady increase in tenancy and a decrease in land ownership. This means that more farmers work on lands they did not own, while fewer individuals, usually wealthy landlords, controlled large portions of farmland. As farms became concentrated in the hands of few, tenant farmers suffered from poverty and exploitation. This imbalance in land ownership eventually led to unrest, especially in central Luzon, where most rice-producing areas were located. One of the notable responses to this inequality was the Sacdalista movement, founded in 1930 by Benigno Ramos, a former government employee. The movement opposed President Quezon and the coming Commonwealth, believing it would only strengthen the cacique system or the dominance of the rich elite over the poor farmers. This opposition led to May 2 uprising, where 60,000 Sacdalistas participated. Unfortunately, the revolt resulted in 69 deaths and 1,000 injuries, but it highlighted the desperate condition of the peasantry and their demand for social justice. Recognizing this growing agrarian problem, the 1935 Constitution included a provision on social justice to ensure the well-being and economic security of all people, especially the farmers. To give life to this constitutional principle, several laws were enacted. Among them was the Rideshare Tenancy Act, or Act Number 4054, passed in 1933. Now that we already know the history of this act, let us now proceed with its salient features. The Rideshare Tenancy Act was designed to regulate shared tenancy arrangement between landlords and tenants. Its main goal was to establish fair and minimum standards to promote justice and equality in agricultural production. Specifically, the law sought to first, strengthen the tenant-landlord relationship by promoting cooperation and fairness. Second, ensure a 50-50 sharing of harvested crops between tenants and landlords. Third, impose a 10% ceiling on loan interest that landlords could charge to tenants. And lastly, prevent unjust dismissal of tenants from the land they were cultivating. So in other words, the act tried to balance the relationship between those who owned the land and those who actually tilted it. Next is the rice share contract defined. What is a rice share contract? So a rice share tenancy is a contract or a partnership between a landlord and a tenant for joint pursuit of rice farming. Both parties share common interest. They divide not only the profits from the harvest, but also the losses that might occur. This provision recognized that both landowner and the farmer contributed to agricultural production. The landlord usually provided the land, tools, and capital, while the tenant provided labor and skills. So under the Rideshare Tenancy Act, it clearly identifies who the landlords and tenant are to avoid confusion in the application of the law. This definition is important because it determines who holds rights and responsibilities under the tenancy agreement. First is the landlord. Landlord is defined as a natural or juridical person who owns or legally possesses the agricultural land being used for rice production. A natural person refers to an individual human being, while a juridical person refers to an entity such as corporation, cooperative, or association that has legal ownership or control of the land. However, Ownership is not only the basis for being considered a landlord. The law also includes those who have lawful possession or control of the land, such as a lessee, usufructuary, or a legitimate possessor. Next is the tenant. So the tenant is the farmer, laborer, or agricultural worker who undertakes to cultivate or work the land belonging to another person. The tenant provides manual labor, skills, or agricultural knowledge to grow rice or the other crops. In return, the tenant receives share of produce or benefits as agreed in the tenancy contract. A tenant may work individually or with the help of family members, but what defines them legally is their direct involvement in cultivation and their dependence on the land for livelihood. The tenant is not a hired labor. Instead, they are a partner in production who has legal rights to the portion of the harvest under the tenancy agreement. Next, we have the execution of contract, which means how the tenancy agreement should be formally made and validated under the law. Under the Right Tenancy Act, a tenancy contract must meet certain requirements to be valid and binding. First, it must be written in triplicate. This means the tenancy contract should be made in three identical copies. One copy is for the landlord, another for the tenant, and the third is for official record keeping at the municipal treasurer's office. Having three identical copies ensures transparency and protection for both parties. It prevents alteration or denial of agreed terms since each copy serves a legal proof of the contract's contents. Second, the language or dialect used must be understood by both the landlord and the tenant. The contract must be written in language or dialect familiar to both parties. This ensures that both landlord and tenant clearly understand their rights, duties, and obligations under the agreement. It prevents exploitation or deception, especially of tenants who may not understand legal or foreign terms. These rules promote fairness and mutual consent, which are essential for valid contract. Third, the contract should be signed or thumb marked by both parties, either directly or through their authorized representatives. For the contract to be valid, both parties must personally indicate their consent by signing or, if unavailable to write, using thumb mark. This serves as proof of agreement and voluntary participation. If the landlord or tenant cannot sign personally, they may authorize someone to represent them, ensuring the act of signing is done with proper authority and acknowledgement. Fourth, it must be done before two witnesses, one chosen by the landlord and one by the tenant. The signing of the contract should take place in presence of two witnesses. One witness represents the landlord and the other represents the tenant. Their role is to attest to the authenticity of the agreement and to ensure that no coercion, fraud, or misunderstanding occurs during the signing. The presence of witness provides additional legal assurance that the contract was executed fairly and voluntarily. Fifth, if either party cannot read or write, one witness must read and explain the content of the contract aloud. When one or both parties are illiterate or unavailable to read, it becomes the duty of a witness to read the entire contract out loud and explain its meaning in a language understood by the party. This ensures informed consent, meaning both sides know exactly what they are agreeing to. It also prevents landlords or intermediaries from taking advantage of tenants by hiding unfavorable terms. Lastly, each party keeps one copy, while the third copy must be filed and registered with the municipal treasurer's office. So after signing, the three copies are distributed properly. One copy stays with the landlord, one with the tenant, and the third is submitted to the municipal treasurer's office for official registration in the Registry of Tenancy Contract. This registration gives the contract legal recognition and enforceability, protecting both parties from future disputes or claims of invalidity.
So let's proceed to registration of tenancy contract. This means the tenancy agreement between the landlord and tenant must be recorded by the municipal treasurer in the registry of tenancy contract to make it official and legal. So when we say registry of tenancy contract, this means the official record book kept by the municipal treasurer kung saan lahat ng the duration of contract. It tells how long the agreement will last. If no specific time is mentioned, the contract is automatically be valid for 1 agricultural year. So, when you say 1 agricultural year, is nakapaloob na dito ang complete cycle of farming activities from land preparation, planting, and harvesting. And it's also when the landlord and tenant wish to continue their agreement, so they must be renew it in writing and register it again within 30 days.
Is agricultural year. An agricultural year is the whole farming period from preparing the land, planting, until harvesting. It may be shorter or longer than a calendar year. Ang calendar year kasi is umaabot siya ng January to December. Here, depende lang siya sa crops. For example, a farmer plants rice in June and harvests in October. That's 1 agricultural year for rice. Gets? So next is the rules governing tenancy contract. A tenancy contract is an agreement between the landowner and the tenant. They are free to make their own agreement as long as it's not against the law or morals. For example, the tenant agrees to plant rice. Ang tenant nag-agree siya na mag-plant ng rice. Tapos, ang landowner na siya ang nag-provide sa fertilizer or sa mga iba pang kailangan. This is allowed as long as it is fair and legal. Fair para sa kanilang dalawa, legal para sa law. The basis of sharing. If there is no written agreement and both the landlord and tenant share equally in expenses like fertilizers, irrigation, and harvesting tools, then the harvest should be divided equally or 50-50 sila. For example, if they harvest 100 na sako, then syempre kailangan nila mag 50-50 sila. So the tenant gets 50 of sacks and the landlord gets also 50.
The next is place where division of crops shall be made. The law says that the division of crops shall be done where the crops are threshed, or kapag naani na. Each one landlord and tenant takes home their own share unless they agreed on something different. The next is loans. The farmers or tenants are allowed to borrow money for farm work, but the interest rate should not go over 10% per year. For example, if a farmer borrows 1,000 pesos, they only pay 1,100 after 1 year. And this law protects farmers from being charged too much interest. The next is the limit of loans. The maximum loan a farmer can get should not be more than 50% of their average earning from the past 3 years. And this rule ensures that farmers don't borrow too much and fall into debt.
So let's proceed to right and obligation of landlord. So for the first one, landlord as manager. So it means that the landlord has the right to manage the farm. This means that they can run the farm themselves or appoint someone else to manage it for them. And also, if the tenant owes the landlord's money, for example, from loans or unpaid rent, the landlord can take up to 85% of the tenant's share of the harvest or income until the debt is fully paid. So, this right is called a lien, which means the landlord has a legal claim to part of tenant's earning until the debt is settled. And for the second one, we have here the responsibility of the landlord to pay taxes. So it means that the landlord must pay all the taxes on the land because they are the legal owner. And also, the landlord cannot force the tenant to pay these taxes because it is illegal to make tenants shoulder the landowner's taxes obligation. So, in short, it means that the landlord can manage the farm or assign someone to do it. So, if the tenant owes them money, so the landlord can take part of the tenant's harvest up to 85% as payment. And also, the landlord must pay all the taxes.
Rights and obligation of tenant. Freedom to work. A tenant who works on a landlord farms is allowed to take another jobs during the times when farm work is not needed. Example, you plant and tend rice from May to August, from September to April. There's no farm work for you on that plot, so you can accept a construction helper job in town. If the landlord asks you to fix their fence during the planting season and that fence repair is outside your normal duties, the landlord needs to pay you for those hours. Right to reimbursement. If the tenant spent money or made improvements for planting, cultivating, harvesting, or improving the crop, and then the tenant is dismissed or removed from the land, the tenant must be paid back for those reasonable expenses before being forced off the land, even if the dismissal was for a justified reason. For example, you advance money to buy seeds and fertilizer and paid hired labor to plant and corn crop. If the landlord terminates your tenancy, the landlord must first reimburse you for those reasonable expenditures before evicting you or taking the harvest. Right to construct a dwelling place. So, a tenant has the right to build a home on the leased agricultural land for their residence and livelihood needs within city limits. So, example, if you rent a 2,000 square meter from 8% would be 160 square meter under the 500 square meter cap. Your fixed residential lot can be up to 160 square meter. You may build a modest dwelling and keep a small garden and a few chickens to support your family.
So now let's proceed to standard of conduct to be observed by tenant. So for the first one, it means that the tenant should properly maintain the land and cultivate the farm responsibly, just like a good father figure caring for their family. This includes properly preparing soil, cutting shrubs and grasses, and repairing dikes. The second one, it means that if the landlord provides work animals, the tenant must take good care of any work animals given by the landlord. If the animals die, get injury, or cause damage due to the tenant negligence,
How contract
the
is
tenant
distinguished.
responsible for it.
So first is, contract is a legally binding agreement between two or more parties, an obligation to perform a specific task or provide a particular service. And we have here the four key elements of contract. The first element is offer. For example, one party makes a proposal or offer to the other party. And the next element is acceptance. The other party accepts the offer. And the next element is consideration. Both parties provide something of value, such as goods, services, or money. And the last element is capacity. Both parties have the legal capacity to enter into the contract. In conclusion, a contract is distinguished by its key elements including offer, acceptance, consideration, and capacity. So the next topic is penalty. A penalty is a punishment or sanction imposed on an individual or organization for violating law, rule, or agreement. Penalties can be imposed by various authorities including courts, regulatory bodies, and contractual parties. The purpose of penalty is to punish the wrongdoing, provide a remedy for harm caused to individuals or society. This topic is the flaws of Rise-Share Tenancy Act. The Rise-Share Tenancy Act is a law designed to regulate the relationship between landlords and tenants in agricultural areas, particularly in rice production. While the law aims to promote social justice and equity, it has several flaws that limit its effectiveness. Some flaws of the Rise-Share Tenancy Act is the difficulty in implementation. The law may be difficult to implement, particularly in areas with limited administrative capacity, and the limited access to credit. The law may not provide sufficient access to credit for tenants, making it difficult for them to invest in their farms.